If you're a personal injury lawyer in Georgia, you need to be aware of new laws as they're passed. Most of the time, new laws go into effect on July 1st of each year, and sometimes they go into effect immediately. Now, after this last legislative session, the governor assigned several laws that will have a bearing on your practice as a personal injury lawyer. Now, one has to do with the threshold requirement for getting a 12-person jury in state court. In the past, if the damages were below $25,000, you would only get a 6-person jury. But if they were above $25,000, you could request a 12-person jury. That threshold damages requirement has now been raised to $50,000. So going forward, if the damages are less than $50,000, you'll only be able to get a 6-person jury. Another important change you need to be aware of is a change to the hospital lien statute. Now, there's a number of different providers who are listed in the statute who can file liens. And in the past, chiropractors were not listed. Now they are. So now chiropractors can file a lien against a settlement or recovery in a personal injury case. Another important change to the hospital lien statute now requires that medical providers bill health insurance if the patient has it. Now, in the past, we've all dealt with medical providers who've refused to bill health insurance. They've tried to file a hospital lien for the full amount of the bill. And this presents numerous problems in helping us get the most money possible into our clients' pockets and in negotiating those liens. Going forward, that problem should be eliminated because now we can cite the law that requires medical providers to bill health insurance before filing a lien. Another important change you need to be aware of if you handle any kind of motor vehicle accidents because you're likely to deal with rideshare wrecks has to do with the insurance requirements for rideshare companies. Now, in the past, if a rideshare driver was actively engaged in a ride, the company had to provide $1 million in liability coverage and $1 million in uninsured motorist coverage. That requirement for uninsured motorist coverage has now changed. The new requirement only requires $100,000 in uninsured motorist coverage. Now, the good news is the liability insurance requirements have not changed. That's still going to be $1 million. But if you are representing a client in a rideshare case, you do need to be aware of the fact that going forward, your client may have access to a lower amount of uninsured motorist coverage. And last, an important law for you to read is SB 74. This new law has 3 separate changes that will be relevant to your practice if you handle personal injury cases. The first has to do with the apex doctrine. Now, that has to do with whether you can depose a high-ranking corporate official in a case. And recently, the Georgia Supreme Court came out with its case of GM versus Buchanan. This new law simply codifies the court's holding in GM versus Buchanan and provides clarity to courts on how a party can request a protective order when an apex deposition is sought. Another change that this law brings about has to do with the State Tort Claims Act. Now, in the past, there hasn't been any requirement that government agencies provide a designee for service of process and to actually make it apparent to those trying to serve the government agency who that designee is. Under this new change to the State Tort Claims Act, state government agencies have to, 1, have a designee who's available for service of process during normal business hours, and 2, the location and address of that designee has to be made available conspicuously on that state agency's website. SB 74 enacted several changes that have to do with false and misleading advertising for lawyers. It's important if you do any kind of marketing as a personal injury lawyer to read the law and to understand what all the requirements are and what the consequences are if those rules are violated.